Alright, let's get started. Okay, so today we have another guest speaker. So she's going to go first. And then after she's done, we'll take a break, and then I'll answer any questions you have about current assignments and talk a bit about intellectual property. For those of you watching the video, she has opted not to be recorded, so we're going to go quiet on the video for now. This is Crystal Vivian. She works for Solution Reach in Lehigh and graduated from here 2 years ago?
2015, 3 years.
3 years now.
Yeah.
Okay. So she's going to tell you what it's like to work there. get started again. So PS11, if I'm not mistaken, was due last night or tonight with a late date. Is that right? PS12 has been out for a few days. It's due a week from today, which is the last day of classes, or the next day with a late date. I think you'll be happy to hear that PS12 ought to be a lot easier than PS11. Anyway, are there any questions or problems I could answer before we do anything else? Yeah?
So I went through PS12 and like got it to where it'll pass that test where it'll do the basic like registering a user thing.
Mm-hmm.
But I'm just trying to get it to respond to a REST call, like getting it to use that like SS listener to notice when it gets a request. I just haven't been able to get it to do that.
Hard to answer in the abstract, I'm sure. Let me take a look, and I imagine I can help. Okay? Any other questions? Either PS11 or PS12? Yeah?
So you said you could use like either PS9 or PS10 for our PS12.
Mm-hmm.
The instructions only showed like PS10. How would we go about using PS9 if possible?
PS9 and PS10 are pretty much the same, except one uses a database and one doesn't. So it'd just be the same instructions, except there's no database. You're still stripping out the support for the web server part. Anything else? Okay. We're going to talk about intellectual property. So, when you read about politics, you'll find any issue that comes up. If Congress does something about it, there'll be someone saying that Congress is overreaching, they're doing things that the Constitution doesn't allow. Or if they don't do something, there'll be people that complain likewise. But intellectual property, and with that I mean things like copyrights and patents, trademarks and trade secrets, but primarily copyrights and patents, are mentioned right in the Constitution. Article 1, Section 8, Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that was a foundational part of the creation of the United States, was Congress had the power to regulate patents and copyrights. When you look at that, do any of those words stand out? Yeah?
Useful.
Okay. Useful arts. Okay. Yeah.
Promote progress.
Okay, so there is the idea behind intellectual property protection is to promote progress. It is, and that, how is that achieved? What's the other word up here?
Well, if your opponent, if your cohort, whatever, produces something that is then intellectual property that you're aware of, you are then driven to compete.
Okay, but what's the word?
Securing an exclusive right.
Well, securing an exclusive right, but the word I'm looking at is limited. Limited time. So the idea behind both copyrights and patents, and we'll look at both of them, is the author or the inventor gets exclusive rights to their invention or their work for a limited time. So if you invent something and you patent it, for a limited time, 20 years, you get exclusive use of that invention. If anyone else wants to use it, you can prevent them, make them pay, whatever. But to get the patent, you have to publish your idea. You have to make the idea public. You can't keep it a secret and benefit from a patent. So the patent system is designed so that people are rewarded for their inventions by getting exclusive use for a time, but society as a whole benefits because the ideas are published. And anyone can look at them and build on them. Yeah?
Don't big tech companies kind of get around this though by not really publishing their secrets?
Well, yeah, if you keep something a secret, it becomes a trade secret. Which just means it's like, example I always use for a trade secret is the formula for Kentucky Fried Chicken. 11 herbs and spices. Or the formula for Coke might be a better example. That formula for Coke has been around over 100 years. It's, I've read various things about it, locked in a vault in Atlanta, and only a few people at a time know it. So if Coke had patented their recipe back in the 1800s, it would now, anyone could make Coke. They didn't patent it, they just keep it a secret. If the secret leaks out, then other people can use it, but they keep it secret, yeah.
But the risk then with trade secret is that, okay, let's say somebody steals your recipe. You can't say, that was my recipe for Coke, that was my legitimate trade secret recipe, you can't have it, because they got it.
Well, yeah, so if someone steals it, then they're guilty of a crime.
Well, I'm saying
But once
once
it's out, it's out. Yeah.
Yeah,
Of course, Coke would deny that
that was the recipe.
that was the recipe. Yes?
Is there any way to renew a patent?
No, patents, no, it's 20-year period. They're not renewable. So anyway, it's for the idea behind the intellectual property system is to help people make progress in in science and arts and so forth. The 4 ways to protect intellectual property. There's copyright and patent. We'll talk about in more depth. There's trademark. So who knows what a trademark is? Yeah.
Something unique to that specific, entity thing.
Okay, so for example, yeah.
So like calling your product Coca-Cola, you can say anything that says Coca-Cola on it is made by us, you know it's good, you know it tastes good, you know that we didn't put asbestos in it.
Okay. Right, so the Coca-Cola is trademarked, so no other company can make another drink and call it Coca-Cola. The way that Coca-Cola is written, the script, the style that it's written, trademark. The shape of a Coca-Cola bottle, trademark. Coke bottles are sort of, anyone have a Coke bottle? I see some cans. They're sort of hourglass shaped. You look at a Pepsi bottle, it's more cylindrical. It's because Coke trademarked that shape for their iconic bottle. Yeah.
I was going to say our Block U is actually trademarked here at the university as well. I don't know how it's trademarked, but it is.
So it's trademarked. The U trademarked their Block U. And so if someone else decides to start printing T-shirts and put the Block U on it, they can be sued for, if they're not paying a licensing fee to the U, they can be sued for infringing a trademark. So do they still have ads with the Jolly Green Giant in it? I don't remember. Yeah. So the Jolly Green Giant goes, ho, ho, ho. Those 3 descending notes, the ho, 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 that's trademark. So you can trademark colors. I think the brown of UPS is trademarked.
Ferrari red.
What's that?
Ferrari red.
Ferrari red's trademark. So it's just a word, a symbol, a picture, a color, I suppose a smell.
You're fired.
Did he trademark that?
Did he do that? That would be terrible.
Wouldn't be the only thing. It's something associated with a product that you got exclusive use to. Those can be renewed. And there's a trademark office, and you register your trademark, and you have to pay a fee. And then if you forget to renew it, then you don't hold the trademark anymore. And that happens from time to time. Trade secret, we mentioned, that's something that you don't want to publicize. You don't want it to be public domain, even if you get protected for 20 years. It's just something that you keep secret. What does any of this have to do with software engineering, since that's what we're talking about? Yeah?
All you really create in software engineering is directly intellectual property. That's
Okay. Right. Anything you produce, anything you write, any program you create, and when it moves from your head to the computer, is copyrighted. You hold the copyright for it. Okay? So copyright isn't something you have to apply for. Just when you commit something to a tangible medium, you hold the copyright. And so that means that anyone else, if you borrow code from someone else, they have the copyright, and you need their permission to borrow it. You were going to say something?
Does it fall under artistic copyright, or what kind of process?
Well, it's copyright because it's written. Things that are written can be copyrighted. They don't have to be artistic. They just have to be written. Okay? So what that means is if you're working for a company and you go swipe some code from somewhere, maybe you just get a snippet from Stack Overflow or whatever, technically, and I guess, you know, I forgot to ask Crystal about it. Eric last week didn't have any experience with having to get copyright clearance. But you could get you or the company in trouble if you borrow code that's protected by some copyright or some license without permission. So there's that. And then patents. Computer programs, or not computer programs, but some of the ideas behind computer programs can be patented. So if you sort of invent a new way to do things, you can patent the idea. Yeah?
When you're employed by a company, is it your intellectual property or theirs?
It's typically theirs.
That's what they're paying you for.
Yeah. So the difference between, if I were to come up with a bright idea in software and get it patented, the U would own the patent. And as part of my employment agreement, I would get some cut. But you know, they would provide the lawyers needed to pursue the patent. But if you're not employees of the U, you know, if you invent something, your programs are yours. So your senior project, or your 3500 programs, whatever, that you hold the copyright. So it helps to know something about intellectual property. Yeah.
What's the standard cut?
For, I don't know.
You haven't tried it?
No, I haven't tried. Okay, so if you're the so talk about copyright first. If you're the holder of the copyright, and you are the holder if you create something, and the word is tangible medium. It has to be written down or recorded or permanently, it has to be stored somewhere. There are various rights you can have as the copyright holder. The right to make copies of the work, to produce derivative works like sequels, to distribute copies, to perform the work in public. Let's say it's a song, to display the work in public. So every type of thing that's copyrighted comes with some subset of the full list of exclusive rights the copyright holder has. Copyright protects expression, not ideas. All right, so the patent is for inventions, for ideas. But copyright is just for something that you have written or composed or whatever. And like anything else Congress does, there are lots of special exceptions for various categories of things. So it's hard to be exactly precise. Just talk in general terms, though. So these are categories of things that can be copyrighted. Musical works, sound recordings, literary works. That's where your computer programs are considered literary works. Dramatic works, movies, pantomime and choreography, sculpture, architecture. So the design of the building is copyrighted. So you can't go and build a copy of some building. You have to get an architect to design a different building for you. A single work can have multiple protections. So if when the Beatles write a song and perform it and record it, there's the copyright of the sheet music. There's the copyright of their particular performances on different albums. There's the copyright of the right to perform in public. And those can all be sold separately. So there was a time when I think Michael Jackson bought the Beatles catalog, and so he held the copyright on some aspects of this to the point where when any of the Beatles performed their songs, they had to pay royalties to Michael Jackson. So copyrights are obviously valuable. Yeah?
You mentioned that currently computer code is copyrighted under literary works. That would mean that a set of typed letters were copyrighted. But if they took the same code and, say, modified it in its machine language form or assembly form instead of its C# or Java form, it wouldn't be the form that had been copyrighted, because it would be the ones and zeros and not the.
But anything that's fixed in a tangible medium is copyrighted. So the compiled form of your code would be copyrighted, the original code would be copyrighted. Yeah?
So I mean, obviously this isn't what's done, but what would prevent someone
Yeah, well, in fact, it's perfectly fine to read somebody's, well, let me put it this way. It's not perfectly fine to read someone's code and duplicate it. But if you independently, if you say, oh, there's a program out there that does this thing, you can write your own program that does that thing without referring to their code, and you can't possibly violate the copyright because you haven't even seen the copy. So what's being copyrighted is not what the program does, it's how it does it. Now, if you did what you suggested, you looked at their code and you wrote your own based on it, but tried to change some things around so that it didn't look like a copy, then that's the subject of a lawsuit there. If it came to that.
Like
people,
Facebook.
Yeah, people would argue about. Yeah, so in the Facebook movie, there's something like that.
Yeah, he saw his code and then wrote his own code and claimed that he didn't copy. He wrote all of his own code, but he looked at the other one first.
Yeah. Yep.
Well, generally for most mediums, isn't there an accepted threshold that you have to change it before it's considered your own? So like, because I know like with painting, you have to change it like 40 or 60% or so. So it can look similar to the artwork and still be considered like of the same style, but it's
right.
not
So there, we're just in the details there of case law and what judges have said in the past. Yeah.
If you have a new idea and you want to just start publishing it or putting it out to the world, how do you go through and verify that somebody else hasn't already had that idea in your
Okay, so with ideas, we're into patents.
Okay.
And we'll talk about that later. But basically, before you get a patent, you got to do a patent search and make sure that it really is an original idea. So copyrights are free. You can register something with the Copyright Office, send them the thing and register it with them, but you don't have to. Whereas patents, you got to spend bucks to hire lawyers to chase everything down. All right, now, built into the law are areas where you're allowed to make copies. And when you use a copyrighted, something written, let's say, without permission, what you have to argue is that you're making fair use. And so there are 4 fair use provisions. So let's say I want to, I decide, I have a video, I have a DVD, and it's about a C# API, and I want to show it to you folks. All right, so technically, I'm violating the copyright because I'm doing a public presentation of copyrighted material. Or maybe I want to show you the latest Star Wars movie in class. So one of those uses is educational. I'm making educational use of the tutorial versus, no, I'm on the wrong work. I'm right there at nature of work. So let's skip down to this one. The API thing is a factual thing. The Star Wars is a creative work. If you can argue that you're under the fair use standards, an argument in favor that you're making fair use tends to favor factual. So you can make a stronger argument if you're using a factual work in a class, say, than if you're using a creative work in the same class. So you have an easier time making fair use of factual things. The purpose of the use, if the purpose is educational, so if I'm showing you Star Wars because we're a film appreciation class and I have some point to make, that's more likely to be considered fair use by a judge than if I am, showing it and charging admission, making commercial use of the work. The amount of the work used. So if I just show you a 5-minute clip from a longer video, that's going to be looked on more favorably than if I show you the whole thing. And then there's the effect on the value of the work. If I do something with that tutorial, for 5 minutes in class, I probably haven't cost who created it any money. On the other hand, if I start showing pirated copies of Star Wars in a theater, I probably cut into their market. Or if I start selling Star Wars DVDs, pirated DVDs, I've cut into Disney's market, and that would affect the judgment. So let's say you violated copyright and are sued, and you argue, oh, I'm making fair use. And the strongest argument would be I was making educational use, it was a factual work, I only used a small amount, and it didn't affect the bottom line of anybody's profit. So people in universities rely on fair use all the time. We sort of rely on the fact that we can take a copyrighted thing and discuss it in class, or copy a magazine article. And, well, back in the day. Now we'd create a PDF of it and pass that around. Yeah?
There's no like copyright police though. I guess if somebody has a problem, that they're going to hit up a lawyer
Well,
and
yeah,
sue you.
yeah. So she asked about the copyright police. So there are, generally, when you violate a copyright, it's a civil matter. And so the copyright holder has to discover what you're doing and sue you. I'm not sure what the definition is, but it can rise to being a criminal matter if the violation is really flagrant. And you see that if you play a DVD, at the very beginning there's this FBI privacy, FBI warning that, thus and such can happen to you. That applies to the big time offenders. Okay, so there have been court cases along the way about copyright. And a really pivotal one was Sony versus Universal in 1984. So Sony is a content provider. Well, actually, in this case, Universal was the content provider. Sony was the maker of VCRs. So Universal Studios was suing Sony because Sony produced VCRs. They first came out then, which allowed people to make copies of copyrighted movies. You could watch something something that came on television. You could make a copy and watch it later. Okay, so this made it all the way to the Supreme Court. Was the use of a VCR to copy television shows fair use or not? And let's analyze it under the fair use statute there. People, recording it and then just looking at it in their own homes. The argument was it's not educational, but it's not commercial either. Right? You're not, presumably you're not selling admission to watch the tape show. You're just time shifting it. But the things being recorded off the TV are created works, so that argues against it being called fair use. Users weren't taping 5 minutes of the movies. When you record something on your DVR nowadays, you take the whole thing. But Universal couldn't show financial harm. They couldn't show that that VCRs were costing them anything. And as I said, this all went all the way to the Supreme Court. And the Supreme Court often does. They decided 5-4. So they found in favor of Sony 5-4 that videotaping was fair use, that it didn't violate copyright. Now, what if they'd won? What if Universal had won? Yeah.
DVRs wouldn't exist.
Well,
Likely than not.
right. So DVRs are the successors, several generations removed from VCRs. Do you think VCRs would have disappeared and DVRs wouldn't exist? No. Probably what would have happened was when you bought a VCR or you bought a blank disc, they weren't discs, a blank tape, you'd be paying royalties to. You'd be paying extra, and the royalties would go to the content producers. Okay? But the ironic thing is, Universal here is trying to stomp out VCRs or restrict the use of VCRs. And yet, nowadays, the existence of things like DVD players, Blu-ray players, whatever, is a significant part of their market. They make a movie and it maybe doesn't cover costs at the box office, but when they start selling home versions, that's where they make their money. So they didn't know that at the time, but they were almost working against their own interests. So the VCR undeniably had illegal uses. But the Supreme Court ruled that you can't sue a company for a device that has many legitimate uses on the basis of some illegal use. So that was 1984. This changed, by the way, at the end of the century, at the end of the last century. New Copyright Act affected that ruling. This was a case in 1992 involving video games. So Accolade figured out how Sega games worked by reverse engineering them so they could produce new games to run on the Sega platform. Okay? Sega sued because they were reverse engineering copyrighted code, I guess, but they lost because Accolade didn't sell copies. They weren't copying the work. They were just using the work to figure out how what the API was essentially, and then creating new games. And there were similar results about reverse engineering that were upheld in the courts as well. Yeah?
So the pressure here should be on Sega to make it so that their stuff is not reverse engineerable, not on Accolade for not reverse engineering and creating something.
Right. So the reverse engineering was okay, and so if Sega wants to prevent it, they gotta encrypt or something. Yeah. Okay, Napster, 2001. They had 50 million users sharing MP3 files, sharing music in 2000. They were sued by the record industry, essentially, and they were defeated. They were flying high. They claimed fair use, but look what's, the copies weren't for educational use. They were of creative work. Entire songs were copied, and the CD market cratered in 2000. And so that didn't fly. So Napster was basically put out of business. Then there were other file sharing services that were sued. MGM sued Grokster in 2005 because they provided peer-to-peer service without a central server. So Napster's vulnerability was they have a central server with all these copies on it. Grokster was just peer-to-peer, so there's no central service. But in this case, they were successfully sued for having a business model that encouraged copyright violation. Okay? So you can think of some legal reasons to do peer-to-peer file sharing. But sharing copyrighted songs was the real reason for Grokster's existence, and so they were sued.
And lost.
Okay, now, things changed with digital media. So before the 90s, if you wanted to violate copyright on a large scale, let's say you wanted to copy books, you had to have a printing press. And you had to have a way to distribute books. So you had to have the same resources as the company that had the legitimate copyright. But things changed in the 90s. It became practical. There are now ways to make digital copies. The problem with analog copies is they degrade over time. You make a Xerox of a Xerox of a Xerox, it's unreadable. But now all of a sudden you can make digital copies that are perfect. You can make them extremely inexpensive. So scan the book, make a PDF. They can be compressed and easily sent over the internet. And so this just solved it didn't take much capital anymore to violate copyrights. So the cost is no longer proportional to the harm. And so that's where the digital Millennium copyright came in. So it was enacted in 1998. It sort of updated the copyright laws to deal with the new digital world. Orrin Hatch, senior senator from Utah, was the head of the committee in the Senate that created the Copyright Act. And I'll finish this next time. I just want to observe one thing. You know how Congress likes to make compromises sometimes. What's the compromise in the DMCA? Just look at the top of the slide. What compromise can you see? See, some of them wanted to call it the Digital Copyright Act. And some of them wanted to call it the Millennium Copyright Act. So the title itself was a compromise. So we will pick up from here next time, talk some more about intellectual property.